Start. The existence of the able as well as the means adopted to check it are the matters for the legislative judgment, but the court is entitled to consider whether the degree and mode of regulation is in excess of the requirement or is imposed in an arbitrary manner. The court has to see whether the measure adopted is relevant or appropriate to the power exercised by the authority or whether it overstepped the limits of social legislation. Smaller inroads may lead to larger inroads and ultimately result in total prohibition by indirect method. If it directly transgresses or substantially and inevitably affects the fundamental right, it becomes unconstitutional, but not where the impact is only remotely possible or incidental. The court must lift the veil of the form and appearance to discover the true character and the nature of the legislation, and every endeavor should be made to have the efficacy of fundamental right maintained, and the legislature is not invested with unbounded power. The court has therefore always to guard against the gradual encroachments and strike down a restriction as soon as it reaches that magnitude of total annihilation of the right. Full stop. However, there is presumption of constitutionality of every statute, and its validity is not to be determined by artificial standards. The court has to examine with some strictness and substance of the legislation to find what actually and really the legislature has done. The court would not be over persuaded by the mere presence of the legislation. In adjudging the reasonableness of the law, the court will necessarily ask the question whether the measure or scheme is just, fair, reasonable, and appropriate, or is it unreasonable, unnecessary, and arbitrary, interferes with the exercise of the right guaranteed in Part 3 of the Constitution. Once it is established that the statute is prima facie unconstitutional, the state has to establish that the restrictions imposed are reasonable, and the objective test which the court is to employ is whether the restriction bears reasonable relation to the unauthorized purpose or is an arbitrary encroachment under the garb of any of the exceptions envisaged in Part 3. The reasonableness is to be necessarily to impose restriction, the means adopted to secure that end as well as the procedure to be adopted to that in full stop. The court has to maintain delicate balance between the public interest envisaged in the impugned provision and the individual's right, taking into account the nature of his right said to be infringed, the underlying purpose of the impugned restriction, the extent and urgency of the evil sought to be remedied thereby, the disproportion of the restriction imposed, the prevailing conditions at the time, the surrounding circumstances, the larger public interest which the law seeks to achieve, and all other relevant factors germane for the purpose. All these factors should enter into the zone of consideration to find the reasonableness of the impugned restriction. The court weighs the each case which of the two conflicting public or private interests demands greater protection, and if it finds that the restriction imposed is appropriate, fair, and reasonable, it would uphold the restriction.